Good afternoon. This is Sean Golding with Golding & Golding here to do a 2025 update for filing your FBAR. The final date to file this year is coming up this week, and so for taxpayers who are a little bit unsure, only learning about FBAR for the first time, let's jump into it. So what is the FBAR, right? The FBAR is Foreign Bank and Financial Account Reporting, not technically an IRS form, but the IRS does enforce it. It's filed on FinCEN Form 114. It's filed because the IRS wants to know about where your foreign accounts, assets, and investments are, even though obviously you don't want to provide it, because who would? It's something that the IRS requires. It's been on the books for 50 years, even though compliance only became more aggressive probably in the last 10 to 15 years. You file the form if you look at all your total foreign accounts combined, and if the value exceeds more than $10,000 on any given day of the year. It's not $10,000 per account, it's $10,000 in what they refer to as annual aggregate total. It includes bank accounts, investment accounts. We'll go into this a little bit more later, but all different types of accounts. You have to report it whether you have ownership of the account, joint ownership of the account, even if it's with a non-resident alien, even if the account doesn't generate any income, even if the account was opened before you became a U.S. person. Also, if you have signature authority, you have to file it. You don't have to have a financial interest in the account. When you do the 8938, that requires a financial interest, but not the FBAR. Who files the FBAR? Well, it's individuals and entities, but this is focused just on individuals. Excuse me. The three main categories of individuals are going to be U.S. citizens, lawful permanent residents, foreign nationals who meet the substantial presence test. If you live overseas, you're still required to file it. There was a recent case, Day, where he had made a treaty election in Mexico. He was penalized for not filing the FBAR in some years, and the court came back and said he shouldn't have had to file the FBAR because he made a treaty election. The IRS still takes the position that making a treaty election doesn't exempt you from the FBAR, excuse me, but that is something to consider. The FBAR is due on April 15th, but it's on what's referred to as automatic extension, which means taxpayers have until October to file the form. You don't have to file an extension form like a 4868 or a 7004. The most important component of filing the FBAR is just to kind of determine what needs to be reported on the account. So generally it's going to be bank accounts, investment accounts, securities accounts. If you have things like mutual funds, ETFs, CCOVs, those are reportable even if they're not in an account. If it's in an account, it's typically going to be easier. You have 15 funds or 15 stocks in one account, then you would just do the total value of the account. If you just own the funds individually, unfortunately, you have to parse them out and list each fund on the FBAR. Individually owned stock typically doesn't go on the FBAR, but it does go on the 8938. Things like life insurance policies, when there's a surrender value, that's reportable. Pension accounts are reportable. And this gets confusing because the IRS had put out some bad information a few years back that didn't distinguish between U.S. retirement and foreign retirement, but the publication 5569 reference guide makes it clear that the IRS does require a foreign pension, your superannuation in Australia, your EPF accounts, all of these types of MPFs, all of these types of provident funds, CPFs, they're all reportable for FBAR. Cryptocurrency is a gray area. If it's a purely 100% crypto account, then you may be able to avoid having to report it for the FBAR, though it's probably reported for the 8938. If it's a hybrid account, if you have any fiat currency in there, if there's any currency going in and out, anything beyond virtual currency, then the IRS would probably take the position that it's required for FBAR. You file the FBAR directly online, and this is important, especially with the way the world is going. FinCEN Form 114, you should go directly to the FinCEN website. If you type in FBAR FinCEN Form 114, you'll find your scammers and ghost sites and mass sites out there that make it look like that's the site you file on, but it is not. And there is no fee to file the FBAR on the FinCEN. So if you're on a website and the logo looks identical, the content looks identical, but they're asking you for $99 or whatnot to file it, then that is the wrong site. So it's very important because this is your personal information. In fact, recently FinCEN updated their website, and the procedures are becoming more strict and the protections are becoming more. If you're out of compliance, this is where it becomes the big issue, right? So let's say you learned about FBAR this year because you had some foreign accounts, but you didn't know you had to report foreign accounts that you owned before you became a U.S. person, or you didn't know you had to report pension accounts. You have to be cautious in filing the current year return before going back and filing other years to avoid the quiet disclosure, but you're in a tough spot if you're hearing this now because it's very close to the filing due date. You should probably reach out to a board-certified tax law specialist to assist you with understanding if there's time. Most people probably are not able to schedule before the 15th at this point. But for those of you who are considering offshore disclosure, there are various different options available. If you're willful, the IRS has a program for you. It's called VDP. There used to be an offshore offshoot called OVDP, but now it merged back into the traditional VDP program. Don't let any tax professional, attorney, self-purported expert try to convince you that because you're willful, you're criminal, and you're going to go to jail. The chance of going to jail is less than 1%. They have a program for taxpayers who are willful, and it's called VDP. If you're non-willful, there's various programs available. The streamlined procedures you'll see a lot, streamlined filing compliance procedures, which is broken down into the streamlined domestic offshore, taxpayers living in the U.S., streamlined foreign offshore, taxpayers living overseas or did not qualify for substantial presence. There are some nuances in that analysis. There's also the delinquency procedures. One, if you just have FBAR, one, if you have multiple forms, and then there's a reasonable cause alternative to the streamlined procedures. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.